Okay, welcome to this short presentation. This presentation is going to be on how to present your case in court. And this is intended to be a general information on what to expect in your civil limited or unlimited case. Note that this is meant to provide information that you will need to know for cases that are not filed in small claims actions. And for anything that's not filed in a small claims case, you are expected to put on your case and adhere to the rules of evidence, pretty much just like anyone else with an attorney. This presentation is aimed at helping you prepare for trial as best as you can because you're choosing to represent yourself or because you're unable to retain counsel. So we will go over what to expect the day of your trial. And just remember that this is not legal advice. And so if possible, you should still consult with an attorney just because the law may be different in your particular case and depending on your facts. The graphic or diagram that you're seeing on the screen now is a general layout of what a typical courtroom might look like, what to expect when you walk into a courtroom. The public seating or gallery is usually separated by some type of barrier and a gate where you walk into what is called the well, is the space between the plaintiff's table, defendant's table, and the judge. So there will be a designated table for the plaintiff and a designated table for the defendant. They're usually side by side. And then next to the judge, you're going to have a clerk. And this is important to know for purpose of admitting evidence. You want to know who the clerk is because she or he will be responsible for taking your exhibits. And then you'll have a witness box where if you brought witnesses to trial, they'll be directed to give testimony from the witness box. Usually the plaintiff testifying or the defendant testifying do not always have to go to the witness box. They can usually just testify from the respective tables, but that's always up to the judge. Next, we're going to go over kind of the sequence of events and how things are kind of presented in a trial. Just keep in mind that this is general information, and sometimes different judges have different case management techniques. For example, if a witness is going to be unavailable later on or has to leave early, a party can make a motion or a request to have testimony taken out of order. And for purposes of efficiency or time, sometimes the judge will allow a party to go outside of the scope of direct examination if that party is just going to end up calling or recalling the witness during their case in chief. And we'll go over what that means in a little bit. So what happens first is the plaintiff has to put on their case in chief. That means they present their case first. The plaintiff will be required to put on evidence to prove that the claims made in their complaint or the legal paperwork are true. As plaintiff, it's not enough to file a complaint, and it's not enough to just come to court and tell the judge your story. You have to get certain points across to the judge, and it's really going to be up to you, plaintiff, to do your research and find out what the elements of your case might be, which we will go over in a little bit as well. When the plaintiff is presenting their case, the defendant has the opportunity to cross-examine either the plaintiff, if that's who testified, or any witnesses brought by the plaintiff. It is not the opportunity for the defendant to, quote, tell their side of the story or deny what the plaintiff is saying, nor is it the defendant's opportunity to argue with any of the witnesses. It's really limited to questions about the subjects and topics covered by the plaintiff or the plaintiff's witness. So the defendant, again, is limited to asking questions. So who, what, where, how, why, of either the plaintiff, if that's who just gave testimony, or the defendant, or the plaintiff's witness, And those questions must be limited to whatever was that the plaintiff or the plaintiff's witness just testified about. The defendant will have the opportunity to go outside of the scope of that and give additional testimony on things not related to what plaintiff just talked about. But that will have to wait until it's defendant's turn to put on their case. So usually the plaintiff will rest, and then it's defendant's turn to put on their case. So now the defendant can go outside the scope of what the plaintiff testified about and put on evidence of either affirmative defenses or evidence that what plaintiff is saying can't be or isn't true. The main takeaway is to remember that after the judge instructs one person to give testimony, the judge will turn to the opposing party and ask them if they have any questions or cross-examination for either the plaintiff or the witness. If the opposing party does not have any questions for that witness, it's okay. The opposing party will have their own turn to present testimony or call their own witnesses. Also remember that the purpose of having an order or sequence of events is so that more than one party isn't speaking at a time. So no more than one party should ever be speaking at a time unless you're making an objection. So what is your case? Again, like I said prior, you want to do some research and find out what the elements of your claim are and what it is that you need to get across to the judge in order to win your case. Some examples are a good place to start if you're the plaintiff is if there's a form complaint, meaning that there's a form that you were able to file in order to file your complaint. That would be a good place to start in terms of researching what the elements of your case are, because odds are that if you had to check boxes on a form or fill out certain questions on a form, it's because those are essential things that the court needs to know about your case. The defendant, on the other hand, has to, again, either present evidence that what plaintiff is saying or what plaintiff was able to prove in their case in chief isn't true, or evidence of their own affirmative defenses. And affirmative defenses are things that if proven, they legally defeat the facts proven by the plaintiff, or they mitigate the legal consequences of defendant's actions. So what that means is that even if the plaintiff was able to prove the elements of his or her case and would otherwise be entitled to a judgment, you as a defendant are able to prove different facts that make it so that plaintiff's facts don't legally matter. For example, plaintiff is able to prove a cause of action for personal injury, and they prove that that an auto accident happened, that the defendant was at fault, and that they sustained damages. And maybe all of that is true and it did happen, but an affirmative defense that the defendant might have is what's known as the statute of limitations. And that basically just means, yes, that may all be true, but you waited too long to file your complaint, so there are no legal consequences to my actions. Common example in unlawful detainers or evictions is where you have a non-payment of rent case or a cause of action for non-payment of rent. It might be true that the tenant, for whatever reason, wasn't able to pay rent and is still occupying the property, and the plaintiff may very well have proven their case. But an affirmative defense to that may be what's known as habitability, which means, yes, I didn't pay rent, but there's a legal reason I didn't pay rent, and that legal reason pertains to the conditions of the property. So now they have to prove what the conditions of the property are and a number of things in order to establish that affirmative defense. So the main takeaway here is you want to do your research on what it is that you need to get across to the judge and be prepared. A recommendation that I have is maybe draw up a chart with 2 columns, and in column number 1, maybe bullet point or list number your elements or your main points. And then to the right of each one of those points, maybe jot down some questions you want to ask of the witness witnesses or witness, or write down the evidence that you have, photographs, letters, text messages, in order to support that claim. And we will get into evidence and exhibits in the next slide. So what is evidence? Evidence is proof, which is legally presented at trial through witnesses, documents, or other exhibits. And exhibits are just the way that the court keeps track of evidence, of anything that's not witness testimony. The exhibits will usually be marked either alphabetically or numerically, and they'll be consecutive. And you, whoever it was that introduced the evidence, or actually both parties, need to keep track of what gets marked and how. Again, maybe some type of chart or just pen and paper. You want to keep track of what exhibit refers to what photograph or what text message. Evidence must be relevant. So that's the #1 rule of evidence. And if you don't know any other rules of evidence, just know that it has to be relevant or material. And what that means is it's necessary in deciding an issue. So ask yourself, what does this fact or this evidence that I'm trying to introduce have to do with either credibility, so disproving what plaintiff is saying, or with what I need to prove to win my case or establish my elements. Like I said, testimony from a witness, that's evidence, but it must be based upon firsthand knowledge. So firsthand knowledge means that you were there to observe it, or your witness was there to either observe it, either by seeing it, smelling it, hearing it. It can't be evidence of what someone else said, what someone else told you, or something that you're imagining or speculating to. Evidence also includes records. So records usually require that the person who created the record be in court, or they could be subject to what's known as hearsay. There is an exception, which is known as the business records exception. And if you'd like to do more research on that, it could be found at California Evidence Code 1271, California Evidence Code 1560. The rules of evidence are very, very complicated. But if you want to try to figure that out, I think those sections are a good place to start. The court will not accept letters from witnesses instead of testimony in court. So consider Zoom appearances. Other evidence includes photographs, text messages, emails, receipts, and some letters. You might be able to get in, depending on whether or not there is an exception. Just know that if a witness wants to submit a letter in lieu of live testimony, that will usually always be excluded. Again, if you take anything away, just know that the rules of evidence are very complicated. You will be held to the same standard as an attorney. And all you can do is your best and be mindful that not everything you think is relevant will be admissible. But if you're prepared, the next couple of slides are instructions or tips on how you might get evidence before the judge and into court. Again, this is general information. There are always exceptions, or the particular facts of your case may not apply to these rules. Keep that in mind. So when it comes to documents, you always want to have copies. Ideally, you want to have 2 copies and no cell phones. So any evidence that you have on a cell phone, you want to have printed out. The court will not allow you to present evidence in the form of a cell phone. And that includes videos, text messages, photographs. There is a way to get video evidence in front of the court, which we'll go over shortly. When it comes to witness testimony, You as the party are a witness. So if you want to give testimony as to what happened, you will be calling yourself as a witness. You will usually be the first witness. The way that you elicit testimony is you ask questions. So avoid having a conversation with your witness. You want to make sure you start pretty much every question with what, who, where, when, why, how. And have a list of questions ready for each witness before you go to court. You might want to use the columns or the chart that I referenced early to maybe keep track of those questions in order to make sure that you're asking questions about things that you need to prove. Another way to elicit testimony is through cross-examination, which I referred to earlier, is when the plaintiff gives testimony or plaintiff's witness gives testimony, or even the other way around, the defendant gives testimony or the defendant's witness gives testimony. The other side will always be given the opportunity to ask cross-examination questions, so long as those questions are related to whatever that party just testified to. Cross-examination is not an argument. It's not argumentative. The purpose is really to either just clarify something that the other party just said, or to question their credibility. I can give you an example. Just remember that cross-examination is not necessary. You will be given the opportunity to present your evidence through your own testimony or by calling your own witnesses. But if you so choose to cross-examine a witness, one reason you might want to do that is because you might be able to get that person to admit that what they just testified to isn't true, if you know it to not be true. So I'm questioning the witness. I'm the defendant. I'm questioning the witness of a plaintiff who just testified as to service. So witness, you said that earlier you served me at 10 a.m., right? And the witness's response is no. So I might follow up with to that by saying, okay, then what time did you serve me? And the witness might say, well, I said 10:30 actually. Okay, well, isn't it true that you were at work on that day from 8 a.m. to 1 p.m.? And the witness might admit to that at that point and say, yeah, actually, I was. Or they might say, no, that was my day off. The person asking cross-examination questions has two options. If you have evidence of facts that are different, or the fact that that witness might be lying, you can present that evidence so long as it's admissible, meaning it's not hearsay. You have copies and it's in a presentable form. Let's say it's a text message from the witness on that day saying, I'm on my lunch break. What are you doing? Well, that's evidence that that person was actually at work that day and it wasn't their day off. And if it's a text message from that witness, then it won't be subject to any hearsay objection, which we will briefly get into hearsay in a little bit. But you don't have to do that. You can also just wait until it's your turn to testify and deny what that witness is saying and say, actually, I was talking to the witness that day through text message, and the witness told me that they were at work that day. So they couldn't have served me with these papers at 10 a.m. because they work. I know that this person works from this time to this time. So that's an example of what you might use a cross-examination for. When it comes to admitting exhibits, there are 3 steps that you have to go through. The first step is you want to ask the court to have the clerk, which is why you want to know who the clerk is and where they are seated. You want to ask the court to have the clerk mark the exhibit so that it can be identified. So this is just so that everybody in the courtroom knows what it is everybody's talking about, a number or a letter. You don't want to approach the clerk directly. You want to you can ask to approach, or usually there's a bailiff in the courtroom who will take the exhibit for you and deliver it to the clerk. The second step is called laying the foundation. And this is just telling the judge what the exhibit is and proving to the court that it is what you say it is. And finally, you want to ask that the exhibit be admitted into evidence. If you don't have it admitted into evidence, it's kind of just lingering out there, and it never really becomes a part of the case. Before you have the exhibit admitted into evidence, the judge will turn to the other party who's not trying to have the exhibit admitted and ask if there are any objections. The court is not asking whether or not the objecting party has any reason to disagree with the facts represented by the exhibit, or to deny maybe the truth of the exhibit. Rather, the court is asking if there's any valid evidentiary rule for why the exhibit should not be admitted, like hearsay, like relevance. Keep that in mind when we go over the next couple of slides. One more thing about foundation. So laying the foundation really just depends on what the exhibit is that you're trying to have admitted. And again, the purpose is so that the court knows that the document is not just a fake or photoshopped, and that you have some degree of personal knowledge that it is what you say it is. So first, we're going to go over a photograph. If you have a photograph, you want to, again, ask the court or the clerk to have the photo marked for identification. And because you have 2 copies, you're going to keep 1 copy for yourself so that you can reference it throughout the case and maybe keep track of what's been marked. And then your second copy is what's actually going to be used. So you're going to show that copy once it's been marked, show it to the other side. And once you've shown it to the other side, then you can explain to the court or to the judge that the photo is a photo of blank. So you want to tell the judge what it is. This is a photo of my car after the accident. Next, you want to explain that the photo is a, quote, fair and accurate representation of whatever it was you just showed to the judge. So a fair and accurate representation of my car after the accident. You must have personal knowledge of what's being depicted in the photo. So you don't have to be the person who took the photo, but you do have to be familiar and have seen what's being represented in the photograph in order to truthfully tell the court that this is what the car looked like on the date in question. And finally, you remember to ask the judge to actually admit the photo into evidence, at which point the judge will turn to the other side and ask if there are any objections. We will get a little bit deeper into these types of objections later on, but just remember that they're evidentiary objections. So not because you disagree with the photo, not because you don't like the photo or because it might be misleading, but because it's should be excluded pursuant to some rule of evidence, or because maybe the person who's trying to have the photograph admitted doesn't have personal knowledge of what's being shown in the photo and didn't accurately state that they were either there or that they've seen what's in the photograph. The court just wants to know, basically, the photo isn't photoshopped, right? Now that it's been admitted, if it is admitted, the proponent of the evidence can use the photograph to explain why or how the photograph supports their position or their claim. And it can be referenced throughout the remainder of the case, which is why you want to keep track of how it was marked. text messages. Again, you will have printed out the text messages from your phone because you can't show the judge your phone. So ask the clerk to mark for identification the copy of the text message you plan to use, show a copy to the other side, and then explain to the judge that it is a text message. Explain who the text message is to and who it is from, and how you know it is to or from that person. State that the copy you brought to the court is a true and correct copy of that text message between you and that person. Again, here you'll be mindful of any hearsay objections. So if this text message is from someone who's not there in court to either admit or deny to the truth of that statement, it may be excluded from evidence by under the rule of hearsay. And then, of course, finally, ask the judge to admit the text message. If it is admitted, explain to the court how the text message supports your claim, or you can always use it to attack credibility or support just some fact of your case, of course. When it comes to email, it's very similar to a text message. Ask the court or the clerk to mark it for identification, show a copy to the other side, and explain that this is an email, or if you're introducing it through a witness, because it's an email from a witness, ask the witness, what is this document? You want to tell the court who sent the email, from what email address, and to what email address. Also, because of the rule of hearsay, which we just went over, and it's a similar issue with text messages and letters, really, you must be the person who either sent or received the email, or the witness must be the person who sent or received the email. Basically, if there are any communications in that email from a witness who's not present in court, it may be excluded because of hearsay. Finally, you want to tell the court that it is a true and correct copy of the email message, or ask your witness, is this a true and correct copy of that email message? Once again, ask the judge to admit the exhibit into evidence, and once it's admitted, you can use it to explain why it supports your claim, or use it throughout the remainder of the case to ask different witnesses questions about the message. Any other types of documents? So this is for documents in general. It might be records, it might be receipts, it might be bills. You want to ask the judge or the clerk to mark it for identification. Show a copy to the other side. Explain what the document is. What is it a copy of? Tell the judge that it is a true and correct copy of blank. This is a true and correct copy of my PG&E bill. Ask the judge to admit it. Again, once admitted, you can use it to explain why it supports your claim, or use it throughout the remainder of the case by referring to it by the marked exhibit number or letter. With documents, you want to be really mindful of hearsay. Again, same as text messages, letters, and emails. Many documents contain statements that are being offered to prove a fact at issue. So if a document is being offered to prove what's being stated in that document, that statement is going to be hearsay if the person who has personal knowledge of it is not in court. Think of hearsay as anything someone else told you, anything someone else said when they are not in court to testify as to the truth of that statement. This will come up a lot with business records or public employee records. Hospital records, utility bills, police reports are considered public employee records. With a hospital record, you'll oftentimes want evidence that someone was hospitalized, for example. The statement is, this person was hospitalized on a certain date. So someone with personal knowledge of that fact needs to be in court to testify to the truth of that statement. And that person would be the person who wrote the record, who put that statement in that record, or the doctor perhaps, or anybody who saw you at the hospital on that date who made that record. There is an exception to have that witness or that person come to court. It's known as the business records exception, which was briefly mentioned earlier. And that's where you have the custodian of records or somebody who's familiar with the record keeping practices of that business. In this case, let's say a hospital. They're your witness. So they can either come to court. We'll talk about an alternative method in a little bit, but ideally they would be coming to court and you'd be introducing the record through that witness. And aside from the other steps, so you'd mark it for identification, show it to the other side. And then when it comes to the second step of having an exhibit admitted into evidence, which is called laying the foundation, you want to ask these 4 questions. Are you the business records custodian, or are you the person responsible for keeping and maintaining records? Yes. Was this record made at or near the time of the event described in the record? Yes. Was the record made and kept in the course of a regular business activity? Yes. And finally, as with most documents, is this a true and correct copy of that record? Yes. At that point, you would ask the court to admit your record into evidence. With step number 2, was this record made at or near the time of the event described therein? The court just wants to know that this record is accurate because it was made right around the time that the event or the thing that's being reported in the record happened, and it wasn't made months later or a year later. And number 3 was the record made and kept in the course of a regular business activity. That's very similar. The court wants to make sure that the record wasn't just prepared for the purpose of litigation. So it wasn't just made so that you can use it in court. It's something that this hospital does on a regular basis. They maintain these types of records, even if there may or may not be litigation. Also be mindful of hearsay within hearsay. So many records, like hospital records or police reports, even if you can get them admitted through these steps and you have a custodian of records or somebody from the hospital that's able to help you with the record to get it admitted, you might have statements of what other people said within those records. And you have to have an independent exception to the hearsay rule in order to have the document actually introduced. So this is known as hearsay within hearsay, and it can be tricky. Just be mindful of it. An example of might be a police report. So the report is written by an officer, and the officer is going to report what the officer may have observed on a particular date in question, let's say at the scene of an accident. The officer is making statements within that report as to what his observations were. But let's say that the officer is also reporting on what a witness at the scene of the accident said happened. So the statements made by that witness contained in that report are hearsay within hearsay. An alternative to having the custodian of records or a witness appear in court to have your record admitted is known as a subpoena. So there is a process by which you can send a subpoena to a business entity in order to have that entity deliver a copy of your records directly to the court. and have the records accompanied by an affidavit from the entity attesting to all of the facts that the court needs to know in order to admit it. The entity will receive the form with instructions on it. They prepare the records described in the form, which gets filled out by you. They sign an affidavit containing the foundational requirements that we just went over, and they deliver it to the court in a sealed envelope that is to remain sealed until your date of trial. There are many rules and procedures that you want to be aware of regarding, for example, how much notice to give the entity and what to do if that entity does not comply with your subpoena. There are also fees that the custodian of records or the entity will require you to pay for making copies of your records and having to deliver them to the court. The subpoena can be obtained from the clerk of the court, and it is issued on a judicial council form known as subpoena form 2. And again, you want to do more research on this process because it can be a little complicated. If it's not done right, then you won't get your records. You can also have physical objects admitted into evidence. Again, you have the physical object marked as you would any exhibit. You show it to the other side so that they can inspect it. And then you explain, what is this object and how do you recognize it? Explain that it is in substantially the same condition as it was at the relevant date or the relevant time in question. For example, in a civil harassment or TRO case, I want to introduce evidence that the respondent threw my phone and broke it. I testified and claimed in my petition that this had occurred, and I want to have the broken phone as evidence of that the court believes me. Have the phone marked for identification, explain that this is the phone that the respondent threw at me. How it is now broken, screen shattered, is substantially the same condition as the phone was in after the respondent threw and broke it. And what that means is that I did nothing to alter its condition. It's not like I took the phone and smashed it to pieces with a hammer to make it look like that's what the respondent did. Be mindful that the phone will, or whatever physical object it is, will be taken into evidence, and the court may or may not give it back to you in a timely manner. So you want to be okay with the fact that you're probably not going to get this piece of evidence back for some time. And of course, don't forget to ask the court to admit it into evidence. And finally, video. You want to have your video copied onto some type of USB device that you feel comfortable giving to the court, because anything that's taken into evidence, you may or may not get back for a while. Do not store anything else on the USB video other than the video or the evidence that you intend the court to see. Do not attempt to bring video on your cell phone. As we mentioned earlier, the court will not take your cell phone in order to watch the video, and you won't get to use that evidence. So ask the clerk to mark your USB for identification. Keep track of the exhibit number. Tell the judge that before today's hearing or trial, you've previously sent a copy to the other side for them to view it beforehand. Sometimes this step may not be necessary, but it's best practice to do this before your hearing. Find a way to send them a copy of this USB or send them an email with the video on it, or even a text message. The court may or may not want to know, out of fairness, if the opposing party has seen the video and might have a good reason to object to it. Next, you want to tell the judge that this is a recording of blank. So explain what the video is, and it's relevant to blank. Tell the judge how or why you were able to obtain this video, and if it has been altered or manipulated in any way. For example, if this is a video from your Ring doorbell camera, you want to tell the judge, I have a Ring doorbell camera, and this was video that I was able to obtain from that, from this date in question, and it's in substantially the same condition or the same form as it was when I first viewed it. The judge will turn to the other side and this is why having the other side view the video beforehand is important, because the judge will ask the other side if they have any objections to the video, and if they've never seen it, then they won't know. So you want to ask the judge to admit the video into evidence. If the video is admitted into evidence, the court will find a way to play the video in court, which is why you want to put it on a USB device, because this is the easiest way for the court to be able to do that. They'll play the video in court, and that's how it becomes evidence. A couple of takeaways here. Documents must be a true and correct copy of the document. Photos must accurately and fairly depict what it is you're trying to show or prove. And a physical object must be in substantially the same condition as it was on the date in question. Finally, we're going to cover objections. Objections are going to be based on the California Evidence Code. Sometimes it's also referred to as the annotated evidence code if you're doing research. Objections are to the type of question being asked or to an exhibit that's being used as evidence. And again, they're based on the rules of evidence and not because you necessarily disagree with an exhibit and want to argue its contents. When a party makes an objection, the judge will either sustain that objection or overrule it. If the objection is sustained, that means that the judge agrees with the objection and the question should not be answered, or the exhibit will not be admitted into evidence. That means that the non-objecting person needs to move on to the next item or the next question. If an objection is overruled, that means that the judge disagrees with the objection. If there was a question being asked, the person asking the question can continue to ask it or repeat the question, and the witness may answer. If it is an exhibit, then the exhibit will be considered and taken into evidence. And again, it can be used and referenced throughout the remainder of the case. When it comes to objecting to the type of question being asked, for example, a question about what someone else told the witness, well, that question is asking for evidence of what someone else said and could be hearsay. So a good objection might be objection, hearsay. Another example, for example, to an exhibit could be a photograph. The photograph might be something completely irrelevant to what the plaintiff or the defendant have to prove. In the steps that we've previously mentioned, when the judge turns to the objecting party and asks if there are any objections to the photo, relevance is a valid evidentiary objection. One more note on objections. When a party makes an objection, everyone should stop talking and listen to what the judge has to say about the objection. Because you have to know whether or not your objection is sustained or overruled. If an objection is sustained and you are the objecting party, then you don't want to have your witness give testimony or evidence that may have otherwise been avoided. So wait to see what the judge is going to decide. Some common objections are relevance, which we've mentioned numerous times. This is the most common objection. It means that something is not relevant to credibility, or it does not make it more likely than not that something essential to the case is true or not true. When a party objects based on relevance, the judge will give the other person a chance to explain why the question or the evidence is relevant and how. Another common objection is speculation. So that means that the witness has no personal knowledge or is asking to guess or assume the truth of something without knowing. And then there's hearsay. Hearsay is evidence of a statement made outside of court where the person who made the statement is not in court to admit or deny it. The main takeaway here is that a proper objection does not go to the truth of the statement. It is being made because the question is irrelevant or the evidence is irrelevant. or it violates some other evidence procedure. And finally, the judge may or may not make a ruling on your matter the date of your trial or your hearing. They may say that the matter is being taken under submission. What this means is that the court needs to review the evidence more thoroughly. They want to review the law, or they just want to give it some more thought. What you should know is that the ruling is going to be issued in the mail, so you should be on the lookout for that. If you think it's been too long, or if you just have questions, you can always call the court and ask if a ruling has issued in your case. Thank you for joining us for this presentation, and I hope that something can be useful from what we went over today.